The honourable member for Brampton West.
Well, thank you very much, Mr. Speaker, and I am very pleased tonight to be speaking to Bill C-54, which, as a member of the Justice Committee, I had the opportunity to review the legislation in detail. I had the benefit of hearing witnesses who would come to the committee and testify with respect to this piece of legislation, and of course we heard people that were both strongly in favor of the legislation, and that, of course, were people who had, of course, been victimized and were victims of people who ultimately became NCR accused. They had certain things that they thought this legislation would do to help them. They had some other comments. We also heard, Mr. Speaker, from some people that had concerns with respect to the legislation. I would respectfully submit that when we deconstructed most of those arguments or concerns that people raised at the committee, those concerns were in fact as a result of either not understanding the legislation or having not read the legislation, or perhaps a combination of both, because most of the criticisms really did not withstand an examination by members of the committee. I want to talk a bit about what this legislation does, and I want to start off with some of the key changes. In my view, one of the key changes that we have, and I'm going to go through 4 of these, in C-54, starts off with making safety of the public to be the paramount consideration when determining whether or not somebody who has been found not criminally responsible is going to be released into the public. And so, as I've often done when I get up and I talk about these particular pieces of legislation, criminal justice legislation, many of the things that we've brought forward, I say that so many of these things that we put forward, they actually just make sense. They make common sense. When you talk to the average Canadian on the street, or, you know, for me, Mr. Speaker, when I go and talk to them in my riding of Brampton West, and you explain some of these things and you say, this is the change that we're going to make with this particular bill. Oftentimes the response is, really? You had to make that change? Boy, it just makes common sense that that would be the law. Why would you have to make that change? So when we talk about safety of the public is paramount, what you look at is when a court or a review board is going to make a disposition with respect to an NCR accused, they're going to take safety of the public as the paramount consideration. Now, not only does that make sense, Mr. Speaker, it is, of course, we're codifying some of Supreme Court jurisprudence in that area. So, in R versus Conway, it was made very clear by the Supreme Court that safety of the public should be the paramount consideration. So when we go through that and when we amend that section, which is section 672.54 of the Criminal Code, we make it clear that when a court or a review board makes a disposition, it shall, taking into account the safety of the public, which is the paramount consideration, the mental condition of the accused, the reintegration of the accused into society, and other needs of the accused, make one of the following dispositions, and here's the next change, that is necessary and appropriate in the circumstances. Again, that just makes sense. You're going to make a disposition that's necessary and appropriate in the circumstances. The next major substantive change is incorporating what we call a high-risk accused. Now, there have been many that have come to this committee and are saying, well, this is going to stigmatize people. I mean, how dare you call somebody high risk? This is a person that has perhaps a significant mental disorder and you're stigmatizing them. Well, I would say the exact opposite, Mr. Speaker. In fact, you're not stigmatizing people that have mental health issues, because what you're actually doing is saying there's a select few that might be high risk. You're destigmatizing everybody else because people then know they are not high risk. So when you look at the section, when you talk about this, and this is where I went back to over and over again at committee when I would talk to people that were raising concerns about these issues. Let's look at the section. quite clearly, section 672.64, it states, on application made by the prosecutor before any disposition to discharge an accused absolutely, the court may, at the conclusion of a hearing, find the accused to be high risk. So first of all, we've got a number of processes that are taking place here. Number one, it's an application that may be brought by a Crown attorney. It's not saying a Crown attorney is going to bring this application for every single person who is found to be NCR. Quite the contrary. I know Crown attorneys. In fact, you know, my wife's a Crown attorney. They're hardworking people. They're not looking for extra work to do. They're not going to go through and try and dig up case files and say, let's try and make this person high risk. No. It'll be reserved for cases where there's a significant concern. And even then, though, even if a Crown prosecutor has that significant concern, it does not mean that that person is going to be designated high risk, because it's a twofold test there. First, the Crown prosecutor has to bring the application. Second, they have to convince a judge that the high-risk designation is necessary in the circumstances. And when we go back to that, we look at what the test is. And so if I go back to the section, at the conclusion of the hearing, the court may find the accused to be a high-risk accused if the accused has been found not criminally responsible on account of mental disorder for a serious personal injury offense, and the court is satisfied that there is a substantial likelihood that the accused would use violence that could endanger the life or safety of another person. When you listen to that section, I mean, when you really take the time to listen to that section, what it's saying is that for a person to be designated high risk, a court has to be satisfied that there is a substantial likelihood that the accused would use violence that could endanger the life or safety of another person. Again, this to me seems absolutely common sense. Why would we consider an absolute discharge where a person is going to be released into the community if they may be at a high risk, a substantial likelihood that they will use violence that could endanger the life or safety of another person? So that's the part of the test that's being changed. I'm quite sure it's going to be used both judiciously by our judges, and it won't be used all the time by Crown attorneys. The second way that someone can be found high risk is if the court is of the opinion that the acts that constitute the offense were of such a brutal nature as to indicate a grave risk of physical or psychological harm to another person. Now, that is a section that a number of people have come to this committee and they've said, oh, wait a minute, no, there's something wrong here. You're going to say it's brutal. You're going to say if it's a brutal offense, that person is therefore high risk. Well, that's actually not true. And a number of witnesses came and made that statement to committee. They actually said, oh, you know, if it's a brutal offense, that person's going to be high risk. So again, Mr. Speaker, I had to walk them through the section. First of all, it does not just say brutal. I mean, when you look at these things, just look at the section. It doesn't say that. It says, if the court is of the opinion that the acts that constitute the offense were of such a brutal nature as to indicate a risk of grave physical or psychological harm to another person. Again, it's saying there has to be some correlation. What we're saying is it's not just brutal. It's brutal such that there's a risk of grave physical or psychological harm to another person. So if anyone wants to get up and suggest that you're saying brutal, high risk, they're not being truthful, Mr. Speaker, or they didn't take the time to read the section and understand what it says. Now, that's not enough, actually. It doesn't just mean that you have to indicate a grave risk of physical or psychological harm to another person. That's not it, because there's another section. Subsection 2 goes on to say factors to consider in deciding whether to find the accused is a high-risk accused. Now, that could be under that first part of the test that I talked about, or the second part of the test. In either case, a court has to be satisfied, and they take into consider all relevant evidence. All relevant evidence. It gives a list, says including, but when you use the phrase all relevant evidence, it doesn't mean actually that you're constrained by the list of factors in the list for a judge to consider. It's a non-exhaustive list. But when you look at it, so not only, even if you accept that argument brutal, you then go down and look at what else has to be considered. The nature and the circumstances of the offense, any pattern of repetitive behavior which the offense forms a part, the accused's current mental condition, the opinions of experts who have examined the accused. So even if someone tried to bring an application under the so-called brutal nature section, a court is going to have to look at all the evidence, which would include such things as the opinions of experts who've examined the accused. So, Mr. Speaker, I think the criticism with respect to, and if I can call it that this might lead to a brutal crime, meaning the person is high risk, is just, it doesn't hold water. It's not a legitimate argument because the section in the statute says something very different. Another issue that was raised at the committee is that the review board, if somebody is designated high risk, that person has to wait 3 years for their review, and that this is not a good thing. Well, I can tell you, Mr. Speaker, that's absolutely not true. It is not automatically 3 years. In certain circumstances, the review for a person who has been designated high risk can be moved to 3 years, but it's not automatic. And it's interesting, actually, because the person that raised that this is automatic 3 years was Justice Richard Schneider, who came to the committee, provided us with his evidence on this, and suggested that the 3 years is mandatory. Well, I asked him if he could show me where it says that in the section, and I understand there was constraints of time. We were talking. He couldn't find it. But when I look at the section, which is right here on page 8 of the statute, look at around line 20, there's 2 ways in which this review can be extended to 3 years. So number 1, it can be moved to 36 months after reviewing a disposition if the accused is represented by counsel and the accused and the Attorney General consent to the extension. So that's number 1. Has to be on the consent of the accused. And of course, because we're dealing with an accused, and in this case in particular an NCR accused, it has to be represented by counsel and with consent of the Attorney General, because of course you want to make sure that you have real and legitimate consent to extend something to 36 months. Now, the other extension is, and I go to the section again, and I keep going back to this, Mr. Speaker, because you have to read the section before you decide to make the commentary. It talks about, at the conclusion of a hearing under subsection 672.47 sub 4 of this section, in respect of a high-risk accused, the review board may, after making a disposition, extend the time for holding a subsequent hearing under this section to a maximum of 36 months, and here's the reason. If the review board is satisfied on the basis of any relevant information, including disposition information, and an assessment report made and offered under a certain paragraph, and here's the key, that the accused's condition is not likely to improve and that the detention remains necessary for the period of extension. So there's a burden of proof that has to be met in order to do that extension. Now, one of the things that was quite clear at committee, this was virtually unanimous, is that review boards do good work. They work hard, they understand the law, and we're putting that decision, the 36 months, back with the review board. Now it's interesting because we did have a witness who came to the committee and who was suggesting that that there's a problem with this 36-month review. Now, again, when you look at the section, it's only if the accused condition is not likely to improve and that detention remains necessary for the period of the extension. Well, interestingly enough, Catherine Latimer, who from the John Howard Society, when I had the opportunity to discuss that with her, her response was that, yes, I noticed that, but you will find if you give very burdened organizations and review boards an option to extend the review periods, they always take it to the outer limit. So she's basically suggesting that a review board doesn't care about what the test is. They don't care if the accused condition is likely to improve or not. They're just going to do it to 36 months because they don't want to work, because they have too much work. This is one of the people that came to the committee to suggest this bill shouldn't pass, and that was the argument. Well, Mr. Speaker, I vehemently disagree with that position being put forward. Now, finally, Mr. Speaker, I'm going to talk quickly about the rights of victims, which is an important aspect of this legislation. I can tell you, I heard what I consider to be, in very many circumstances, absolutely heartbreaking testimony from people who came to talk about family members who had been killed by an NCR accused, to talk about children, their children being killed. These things, you hear them, and it is very difficult to listen to that kind of testimony. But what I can tell you is some of the things that they were unhappy with and things that we want to fix. We can't fix what happened, and we all know that. But some of the stories, for example, and I can't remember who came and told us this story, but they were walking in a mall, and bang, they bumped into the person that had, the NCR accused who had committed those acts of violence against their family member, and they were in a panic. So guess what? One of the things we have in here, in this section, in the revision in this act, is notice of discharge of an NCR accused to the victims. So they're going to receive a notice when an NCR accused is going to receive an absolute discharge. What a huge step up that is. Now, victim impact statements. We're also making victim impact statements mandatory to be, if the victims want to make a statement, they have to be considered before a disposition is made. Non-communication orders, again, so that if a victim does not want communication from an NCR accused, they don't have to have it. Common sense seems to make sense. And Mr. Speaker, what I can say in a great example of some bipartisanship at the committee, an amendment was brought forward by my colleagues in the NDP with respect to let victims know the intended place of residence of the NCR accused. Now again, that goes back to that story of someone bumping into the NCR accused in the mall. If you know they're being discharged, you know where they're being discharged to, you increase the chance that you're not going to have that unfortunate incidents. I know I'm running out of time, Mr. Speaker, but I want to point out another thing that was raised at committee was that NCR accused are going to be put in jail. That's what this legislation does. That was put forward by Mr. Fedorov, Dr. Paul J. Fedorov. And so I asked him, where in the legislation does it say that an NCR accused is going to go to jail? Couldn't point it out. In fact, I then walked him through the section to talk about what happens. And when you deal with an NCR, when you deal with someone being deemed high risk, they get put into treatment. And you go back to terms of disposition, which is section 672.54, sub C. And it says, by order, direct that the accused be detained in custody, and here's the key, in a hospital. So somebody who's designated high risk is not going to jail. I don't know where that came from. It's not true in the legislation. They will be put in a hospital for treatment. And when I pointed that out, the response was that, well, before they are declared NCR, they're going to be put in a jail, and that's the problem. Well, the answer to that is, that's what the system, how it currently exists. And when somebody has committed a serious crime and they're awaiting trial, if they don't get bail, they're in jail. This does not change that. Mr. Speaker, this is a piece of legislation that is going to be moderately used. It's a tool, I like to call it, it's a double check. When a review board is about to absolutely discharge somebody, an NCR accused, there can be an application to court to say, hey, wait a minute, we think this person might be high risk and could reoffend and commit violence. Court, can you please look at this and make sure this is the right disposition? It's a sensible, reasonable safety check, and I hope it has the support of all members in the House of Commons. Thank you, Mr. Speaker.